Do you have any questions about Women for Kansas, the organization? Thank you for coming. Today we're going to hear from Nicole Revenaugh. She's a civil litigation attorney at Irigonegaray Revenaugh, a law firm dedicated to representing plaintiffs in personal injury and wrongful death actions and providing competent criminal defense. Her firm also engages in civil rights litigation to protect reproductive freedom and voting rights and ensure equal protection of the laws. She serves on the Alumni Association Board of Governors at Washburn University School of Law and is a past president of the Women Attorneys Association of Topeka and past chair of the Kansas Women Attorneys Association Annual Conference. She's also served as interim judge pro tem of the Shawnee County District from 2019 to 2021. And Nicole is here speaking today on behalf of Kansas Women Attorneys for Freedom, a 501c4 nonprofit corporation founded in 2022 by women attorneys across the state. Their mission is to advance, promote, empower, and protect women in and out of the state of Kansas. And with regard to the judicial system, one of their primary objectives is to support the independence of the judiciary, including the merit selection process. At the end of the presentation, we'll have a time for question and answer. But right now, help me welcome Nicole to the class.
Okay, good afternoon, everyone.
Good afternoon.
As Kelly mentioned, my name is Nicole Revenaugh, and I have a practice in Topeka that focuses on civil litigation, but more importantly on protecting civil rights and constitutional freedoms, including reproductive freedom, voting rights, and equal protection of the laws in Kansas. I want to thank Kelly Wall and Women for Kansas, Lawrence Douglas County chapter, for inviting me to speak today on what has become a very important topic. As she said, I'll spend about 45 minutes going over the ins and outs of the Kansas court system and how the proposed constitutional amendment jeopardizes the ability of our citizens to keep Kansas courts free from political influence. Then, as Kelly mentioned, I love discussion, so I've left quite a bit of time at the end so that we can just have some engagement. So please think of your questions, hold them, and then we'll get to them at the end. As Kelly mentioned, I'm here today on behalf of Kansas Women Attorneys for Freedom. We were formed in 2022 in direct response to the Dobbs versus Jackson Women's Health organization case decided by the U.S. Supreme Court. And as we know, that decision effectively ended the federal constitutional right to abortion as protected under Roe v. Wade and returned the authority to regulate abortion to individual states. So the mission of KWAFF is to, again, advance, promote, empower, and protect women. As an organization, as I know Women for Kansas did, in 2022, we raised funds and purchased signs and buttons and swag, and we spread education and information about the 2022 amendment and its consequences for and against throughout our state. I know that your organization had a tremendous impact on the success of that measure, and so I am extremely appreciative as a KWAFF for all of your efforts as well. Our membership includes attorneys across the state. We represent a variety of individuals and corporations, everything from criminal defense to tax advice. And with regard to the judicial system in particular, one of our primary objectives is to support the independence of the judiciary, including the preservation of our merit selection process to appoint our judges and justices. We also advocate for women's reproductive freedom, and we actively engage and empower women to attain key leadership positions in the private, public, and government sectors. So I'm big on roadmaps. We can kind of talk about where we're going today. So this is our 30,000-foot view of our discussion. And I think it's important first that we talk about the history and role of the Kansas court system, and how we came to even institute the merit selection process for the selection of our state Supreme Court justices. We're also going to discuss how the merit selection process actually works, the ins and outs, who serves on these commissions, and how does one successfully apply and become a judge or justice on the court. And then next, we'll talk about the role of Kansas citizens in participating in our retention elections. And that's where we have the ability to vote on whether a judge or justice should remain on the court for an additional 4 or 6 years, depending on their term. And then, of course, we're gonna talk about our constitutional amendment, which will be on the ballot next summer, August of 2026. That amendment proposes to change the selection of our Kansas Supreme Court justices from the merit-based, nonpartisan selection process to an open, statewide partisan election. And then finally, we'll talk about what the potential impact that a statewide election system could have here in Kansas, and what impact it will have on our ability to ensure that we maintain fair and impartial courts that are free from political influence. So just like the federal government, we have 3 co-equal branches of government here in our Kansas state system as well. Legislative branch obviously makes the laws, executive branch enforces our laws, and the judicial branch, which is our referee, right? They interpret and apply the law to specific situations with the litigants before them. We also have 3 levels of courts in Kansas. District courts are divided into 31 judicial districts, and we have courthouses in every county in Kansas, all 105. The district courts are the court that is usually the first to hear a particular case or grievance. Then the Court of Appeals is our intermediate court. It's made up of 14 judges, and they hear appeals from the party who usually lost at the district court level in both civil and criminal cases, and they usually hear these cases in panels of 3 judges at a time. But they also have the ability to hear a case en banc, which means all 14 judges would sit and listen to an argument and have a vote in the decision. The Court of Appeals has an insanely large caseload. They hear by far the most cases between all the courts, and that's because criminal defendants have an absolute right to appeal an adverse verdict or sentence that they disagree with, and so they are hearing often every single criminal conviction be appealed up to the Court of Appeals. And finally, the Kansas Supreme Court, that is the highest court in our state court system. It's made up of 7 justices, and they have a jurisdiction to interpret our Kansas Constitution, which in many ways does mirror our federal Constitution, but has some differences. It also will interpret statutes that are passed by the Kansas legislature, and sometimes even federal statutes and regulations that are passed by Congress, in which they're called to make an interpretation as it relates to a situation in Kansas. The Supreme Court usually hears cases first heard by the Court of Appeals, so it's coming up on another level of appeal. But they also hear direct appeals from the district courts under special circumstances and in cases where a statute has been declared unconstitutional. So Kansas Supreme Court decisions set binding legal precedent that all Kansas courts must follow. Only the Kansas Supreme Court itself, and in some limited circumstances, the U.S. Supreme Court can overrule a decision that's rendered by the Kansas Supreme Court. So how are our judges and justices selected for the bench? Kansas is a little unique in that our district courts first have a variety of methods in which we determine how we select our judges. For example, Sedgwick County has 30 district court judges, Wyandotte County has 16 district court judges, and they actually have partisan elections where each candidate affiliates with a political party, or they can run as an independent. And they participate in the election process just like any other politician who would run for a state office. In fact, 14 of the 31 judicial districts across the state actually have partisan elections to select our lowest level courts, our district court judges. Now, the other 17 districts, which include Douglas County, Shawnee County, Johnson County, to name a few, we have a merit-based system of appointment. And that generally involves a nominating commission that reviews applications, they conduct interviews, and then they select 3 finalists who are set in front of the governor. And then the governor chooses among those 3 finalists and makes a selection to the vacancy in that particular court. And we will talk in detail a lot more about this later. The Kansas Court of Appeals process also contains a nominating commission that interviews candidates and narrows down to 3 finalists. But what's different about the Kansas Court of Appeals is that after the governor makes her selection, the candidate asks to go through a confirmation process in front of the Kansas Senate. And that's a simple majority vote where each senator decides whether this person is qualified and capable of sitting on the court. The appellate judges serve 4-year terms, and they sit for a retention election at the end of 4-year term. Okay, now let's talk about the Kansas Supreme Court. Kansas Supreme Court was established within the constitutional framework in 1861 when Kansas became the 34th state to enter the Union. And at that time, the Kansas Supreme Court had only 3 justices. But remember, we didn't have a whole lot of people back then, so that covered it. That number expanded to 7 in 1900, again by constitutional amendment, and the court continues to have 7 justices to this day. For over 45 years, the citizens of Kansas had a partisan election process. We elected individuals by popular vote who would serve on the Supreme Court, except there was one exception to that rule. If there was a vacancy on the court, the governor could just appoint someone to fill the seat. They didn't have a mechanism to have a special election the way we do now for a lot of seats to become vacant. And so the governor would appoint someone and they would just wait for the next natural election cycle to have a new election for that seat or for whatever seat's term was up next. And this system appeared overall to work pretty well for Kansas for a while. And then in the mid-1950s, there was a major shift in attitude towards the court due to a notorious scandal, because we have to have scandal, right? And this scandal was called the Triple Play. So here's what happened in the Triple Play. In 1956, Fred Hall, who was then at that time governor of Kansas, he lost his bid for re-election. But the governor refused at that time to accept that his time in power was over. No. Sounds familiar. And so he schemed to install himself as a justice on the Kansas Supreme Court. Well, how can he do that? You know, the seats are filled. And what's crazy to me is that his chief co-conspirator in the whole scheme was the actual Chief Justice of the Supreme Court himself, and that was William Smith. Apparently, Smith and Hall were not only friends, but Smith supported the governor's failed attempt at re-election, so he was also bummed out that his friend would no longer be the governor. So to accomplish this scheme, both Governor Hall and Chief Justice Smith essentially resigned from their posts at the same time. And as soon as the Lieutenant Governor, John McEwish, was sworn in as governor, he appoints Governor Hall to be the Chief Justice of the Kansas Supreme Court. It was the only official act during the 11 days that McEwish was governor. So of course, this shameless political episode did not sit well with the people of Kansas. Surprise, surprise. In fact, they felt so strongly about keeping their court free from this political influence that in 1958, they had a constitutional amendment and voted to change the state constitution and move from a partisan election process to a merit-based appointment. And they did that to ensure that our judges were selected based on their qualifications, on their legal acumen and their experience, and their ability to give fair and impartial rulings to all Kansans. They essentially said, No more partisan scandals. So, like the Court of Appeals, Kansas Supreme Court also has a nominating commission that reviews and interviews candidates and then submits the name of 3 finalists to the governor for appointment. But whereas the Court of Appeals has that extra layer of going through Senate confirmation process, we don't have that with the Kansas Supreme Court. Once the governor selects the appointment based on the 3 finalists, that person is sworn in to serve on the Supreme Court. And importantly, even though our justices are selected through a merit-based process with governor appointment, the voters of Kansas do have a say as to whether to retain each justice during the state's general election process. And these are called retention elections. When you have your ballot and everyone says flip over your ballot, and you see the names of all these people you don't know, and it's yes, no, yes, no, yes, no. Those are our judges and justices. As an attorney, I appreciate you taking some time to consider them when you vote. So every justice who serves on the Supreme Court must sit for retention first in the very next general election that occurs after his or her first full term or full year on the bench, right? So they have an accelerated first retention election. But after that, he or she will remain in office for a term of 6 years. So no matter how long that justice has served, every 6 years they will sit for retention on the ballot, and the public is asked in a simple up or down vote to decide whether each judge or justice should continue to serve on the court. One interesting and increasingly important fact about retention elections is that judges and justices at all levels are not permitted to engage in political activity of any kind. They cannot accept financial contributions, even though their names will be on a public ballot. Instead, they rely on their performance record. They spread information and education about how the courts work, what kind of decisions they're rendering, what kind of work they do, in the process and purpose of retention elections. And so far, every single justice has always been retained in these retention elections. And that's the case even when, in recent years, we've had special interest groups actively campaign against their retention. And in my opinion, that demonstrates that regardless of how one may view a particular judge's opinion on a certain issue or a particular case outcome, that the citizens of Kansas unanimously agree at the time for retention that these judges and justices are qualified to continue serving on our procedures courts. So let's talk a little bit about the Supreme Court Nominating Commission in more detail. The commission is made up of 9 members. There are 5 lawyers and 4 citizens who are not lawyers on the commission. The 4 lawyers are elected by popular vote by members of the bar, meaning fellow attorneys and judges. 1 from each of our 4 congressional districts, which are no longer linear, as I understand. Lawrence is now part of the big purse. And that ensures geographic, urban, and rural diversity. I think that's actually a really important point. You know, we don't have 4 lawyers from Kansas City or Johnson County or Wichita. It is intentionally diverse in who can run and in where that person has to live in residence in order to serve on the commission. Then the 4 people who are not lawyers are actually all appointed by the governor to serve on the commission. Finally, the chair of the commission is an attorney, and they are elected in a statewide election by members of the bar, again, attorneys and judges. So when there's an opening on the Supreme Court, the nomination process is publicly announced, right? There's no secret swap out where one judge resigns and the next day another judge is there. So it's publicly announced that there's going to be a vacancy on the court, usually due to someone's retirement. And it gives individuals an opportunity to prepare and submit applications. And this application packet, I've seen it, is about 1.5 inches thick. Okay, this is not submitting your resume online through an e-portal and hoping for the best. It's a very thorough process. It of course includes the attorney or judge's resume, a list of references and letters of recommendation. It has a list of all cases in which an attorney or judge has ever worked on or rendered a decision in or had a vote in. It's an extremely long list for most of the individuals who are applying for the court. And each candidate is then assigned both a lawyer member and a non-lawyer member of that commission to basically say, I'm going to be the two people to review your packet more thoroughly than anywhere else. They call the list of references, they meet with the candidate several times, and then they build a summary report that's then presented to the greater commission. Then after all of that vetting has taken place, all of the background checks and the work history and making sure this person is fit to serve in the office, the commission comes together and they discuss the findings of each candidate, and then they have a 30-minute publicly televised interview. So it's on YouTube, it's there live, but it's also there after the fact. And you can view the interviews that are taking place. You can see the questions that are asked, you can see how each of these people answer those questions. And after that process is done, the nominating commission will deliberate and narrow the list of applicants to 3 finalists. Those 3 finalists then go to the governor for consideration. The governor's office has its own vetting process that they go through to decide who would be the best selection for the court. And then that governor makes their appointment. So why are we here discussing the courts and the nomination process and how we pick our judges and justices? Because I imagine there's a lot more fun things to do Saturday afternoon. And that's because this session, the Kansas legislature narrowly passed, and when I say narrowly, I mean 1 vote in the House, 1 vote in the Senate. Thank you, Senator San Francisco. Almost, right? Almost. So SCR 1611, that was a Senate concurrent resolution, and it calls for the abolition of this Kansas Supreme Court nominating commission. Because remember, because the court was created in our Constitution and can only be amended through our Constitution, they have to move some mountains to even get to the place where they can have the citizens vote on a ballot. They can't just pass a bill and say there's no more Supreme Court nominating commission, and that's why we are going to be involved in this public process. But they did. They passed what they needed to, the concurrent resolution, so that it's put in front of the public, in front of the voters next summer. So on the ballot in our primary election in 2026, sound familiar? 4 years from August 2022, we're going to have our next and most important vote that we've had since that time. And that will be a proposed amendment to the Kansas Constitution, which, if passed, would return Kansas to a partisan, statewide election of all of our Supreme Court justices by the citizens of Kansas. It would also permit explicitly Supreme Court justices and candidates who oppose them and run against them to engage in political activities, to receive financial contributions, and to even hold an office in a specific political party. So, I know you all cannot read everything on the screen. I'm going to read it. But I want, you know those explanatory statements on our constitutional amendment questions that are supposed to help us understand what we're voting for and against? I just want to read what will be on the ballot. Because as we know, and as this organization well knows, that's never the end of it, and there's a whole lot of education and information that needs to happen between members of the public so that everyone has clarity about what their vote means when it comes to election day. So the meat of the explanatory statement says the following. This amendment gives the voters the right to elect the justices of the Kansas Supreme Court. The justices shall serve terms of 6 years, with the elections of justice positions 1, 2, and 3 to occur in 2028, positions 4 and 5 to occur in 2030, and positions 6 and 7 to occur in 2032, and every 6 years thereafter. So what this means is we're not gonna have, if this passed, we're not gonna have an election where all 7 justices are up. right off the bat in 2028, and we just have a circus to figure out what happens to the court. They're doing this strategically, and so it would be 3 justices in 2028, 2 in 2030, and 2 more in 2032, and then that would create a rotation where you're always going to be voting on 3 or 2 justices every 2 years. So to continue with the explanatory statement, it says, a vote for this proposition would give Kansas citizens the right to elect Kansas Supreme Court justices as provided by law. Justices will hold office for terms of 6 years. And yes, they are repeating themselves in this explanatory statement. The Kansas Supreme Court Nominating Commission, whose membership consists of a majority of lawyers, those jerks, would be abolished, right? So it's explicit that they will abolish the Kansas Supreme Court Nominating Commission. And finally, a vote against this proposition would continue the current system in which the Kansas Supreme Court Nominating Commission, whose membership consists of a majority of lawyers, provides the governor a list of 3 individuals to choose from for vacancies on the Kansas Supreme Court. They do such a good job with these, don't they? I mean, so let's break that down a little bit more. What does this actually mean when we go to vote? A yes vote. If you vote yes, it would do the following. It would eliminate the Supreme Court Nominating Commission, which means no more merit selection process of any kind. Any future vacancy on the Kansas Supreme Court would be decided by a public statewide election by citizens of Kansas. It would expressly permit any candidate and any sitting justice to affiliate with a political party, hold an office in that political party, and receive and expend political campaign contributions. So essentially, our Supreme Court justices would become pseudo-politicians running statewide campaigns every 6 years. And there's far from any guarantee that a particular attorney or judge's merit or qualifications will have anything to do with whether that person wins the partisan election. So if you vote no, we're gonna leave the Supreme Court nomination, the commission and the merit selection process in place as it is. So this is not an either or proposition, and I think that's important. Vote no means no change. Don't change what we're doing. It will continue to disallow partisan elections for Supreme Court justices. And it will, by its own merit, prevent the politicization of our courts by not allowing justices to accept political campaign contributions or to affiliate with political parties in order to be retained or to win their seat, okay? And that's important. So again, for the retention elections, even though sometimes, honestly, it's tricky, because people can campaign against them, they cannot participate in a political process, even for their own retention vote. So imagine trying to keep your job without being able to talk about it. That's what they have to do, but there's a lot of citizens and organizations that help spread education about the role of the courts, and so far that's been very successful. But I think it's important that we recognize that they are not allowed to participate in the political process, and if you vote no, that is what would continue. They would not be allowed to be political. So, why now? Why this year? Why this legislature? I ask this question every year about various things that are passed in the legislature, but why is this coming to bore now? And I think there's some different theories as to why the Kansas legislature acted to try to change the makeup of the Supreme Court. And so I would say this section of our presentation is very much just me thinking through why would they do it and what's going on. And what I've come up with is that for several years, a group of conservative legislators and leadership have taken issue with some of the Supreme Court's opinions, right? They don't like what they've decided. The first was the Gannon versus State of Kansas lawsuit, which was actually a long-running series of cases that began back in 2010, and it challenged whether the Kansas legislature was adequately and equitably funding K-12 public schools. And as you recall, during the Brownback administration, the golden years of Kansas, that our school funding was cut repeatedly when our tax system had been cut so severely that we could not fund our public schools. And finally, a lawsuit was filed challenging whether those cuts were so severe that it violated our state's constitution. And that case again went on for several years, and ultimately the Supreme Court did hold that yes, the legislature has violated our state constitution by failing to adequately fund the schools, meaning how much money was allotted to public education. And they were also failing to equitably fund the schools, which means how is this money being divided between the school districts? And is it being fairly apportioned to ensure that each student was getting the same public education? The second major case was a series of lawsuits called Hodes and Nauser. There's been many, and there may be many more. Hodes and Nauser are two very courageous women's reproductive physicians who have challenged consistently any legislation that directly or indirectly impacts a woman's access to reproductive health and safe and legal abortion in our state. In 2019 and again in 2024, our Kansas Supreme Court, within the Hodes and Nauser's framework, recognized that Article 1 of our state constitution, which also, like our federal constitution, says we have the right to life, liberty, and pursuit of happiness, includes within that inherently the right to bodily autonomy, and specifically a woman's right to terminate a pregnancy if she needs to or if she so chooses. And of course, these decisions do not sit well with our conservative state legislature. And they often attempt to buck these decisions and pass legislation each session that attempts to undermine the Supreme Court's rulings, because they're constantly trying to figure out a way back to get a different result. So the final reason I think the legislature has taken this extreme step of passing a resolution to invite the partisan election of our Supreme Court justices is that they like their odds, right? They want the court to reflect the ideology of the legislature. Because if they do that, they're not going to be told all these laws are unconstitutional anymore, right? That's what they're hoping for. Because it's no secret, no matter how hard some of the individuals in this room work, and I know you do, it's no secret that partisan elections generally favor one party in our state. And with the exception of the governor's office, the vast majority of statewide offices that have public election have resulted in the election of the Republican candidate, and that's been consistent for at least the last 100 years. So if the amendment passes and Kansas begins to elect Supreme Court justices, there's a very good chance that the Kansas Supreme Court would no longer be what I believe is a very fair and balanced makeup of judges, but would start to lean conservatively over the next few decades, or not longer, if not longer. So now that is great news, let's talk about what would happen if we move to that partisan election system of our Supreme Court justices. And the best way I can think to do that is to talk to you about what's happening in other states. And a lot of you may already know what I'm going to talk about here. Our most famous and best example is the state of Wisconsin. Wisconsin already has a system in which they do partisan elections for their state Supreme Court, and it's in the same manner that our constitutional amendment question would propose for Kansas to participate in. So something very important happened in 2015 in Wisconsin, and that's that their state Supreme Court approved unlimited spending in political campaigns. So it was the state version of Citizens United, right? We're not going to restrict speech. Money is speech. Pour as much as you want to these campaigns. So in 2023, Wisconsin Supreme Court election, you had $51 million spent in that race for the election of a single Supreme Court justice. Out of the $51 million spent by the candidates in that campaign, $45 million came from sources outside the state of Wisconsin. So when we talk about dark money, It's a nice catchphrase, you know, it sounds ominous, but what it means is that we can't trace it. That there is an end to where we can figure out the source of the funds, who donated the funds, and how much they're donating. It's basically an unrestricted bank account. And so when we talk about dark money coming into the state, it's not the citizens who are donating $20, $50, even $1,000 here and there. It's billionaires and interest groups and people with hundreds of millions of dollars pouring in at whatever amount they think is going to influence the outcome of this race. So just a month ago, to provide a new data point, and what all gave us tremendous hope for this country, Susan Crawford defeated Circuit Judge Brad Schimmel in another Wisconsin Supreme Court election, and that was again for a single seat on the Wisconsin Supreme Court. And remarkably, the amount spent on the Crawford-Schimmel campaign was over $100 million, more than double what the same election cost just 2 years earlier. Our friend Elon Musk personally donated over $20 million to that campaign. And as an easy reminder, he is not a resident of the state of Wisconsin. So I'm really not sure what he was so interested in over there. He also gave out $1 million checks to people who promised to vote in favor of Schimmel or of conservative judiciary, however he cashed it. He was literally paying people for their votes. And in comparison, Kansas has never had more than $22 million spent in a particular race. And we set that record with our own abortion amendment in 2022. And to be fair, we were the first state after Dobbs versus Jackson Women's Health to have any sort of public vote or referendum on what an individual state would now do, now that the power to make those decisions came back to the states. And I would tell you that 22 million at that point in time was an unprecedented amount of money for Kansas. That's not how much it costs to run for governor. It's not how much it costs to run for Senate. Barbara Bollier had a giant Senate campaign in 2020, and I think only spent $14 million, and that was an unprecedented amount at that point in time. So I say that to say it continues to climb. But as it continues to climb, it's not because we all of a sudden made more money and had the ability to donate more. It has nothing to do with the citizens of the state in which we're actually holding these votes. Bigger and bigger interest groups are finding reasons and ways to donate massive amounts of money to flood into our state to influence our courts, our political figures, and the outcome of our elections. So this is one stark reality of what, Kansas partisan elections would do to our Kansas Supreme Court. And I want to speak to that for a minute. The reason we went through the history of the courts is our Supreme Court justices are the final decision maker for our citizens, for individuals, for businesses, for any disputes that we may have. We rely on them to be free from bias and undue influence. We don't want to worry about whether a foreign entity is involved in an environmental dispute for Clinton Lake. We shouldn't have to worry about whether there's special interests that have nothing to do with the state of Kansas influencing our justices or favoring our high-profile litigants or attorneys who appear before the court. And I think the impact of having that happen, even if our justices endeavor to be unbiased and free from influence, even when they're accepting political contributions, is that would cause our citizens to question the integrity, the reliability, even the authority of our system that allows lawyers and corporations to donate to a judge's campaign and later appear in front of that same court and for both sides to expect a fair and impartial ruling to occur, free from any financial or political influence. We just know that that's not the feeling we're gonna have. So why is it important to keep Kansas courts free from political influence? For nearly 70 years, this merit-based system with the Supreme Court Nominating Commission and the governor appointment process has worked well under both Republican and Democratic administrations. And honestly, it does ensure that there is a fair and impartial court insulated from political pressure. There's been a lot of polling since this resolution was passed because people want to know, what are the citizens thinking? And right now, a poll by Global Strategy Group said that 66% of Kansans believe the current system, which is the nominating commission and merit selection, is a fair and impartial system for Kansas. So that gives me a lot of hope, and I think that's a number we need to continue to hang our hat on as we do the work to defeat this amendment. So right now, we do indeed have a very balanced court. These justices have been appointed by 5 different governors, both Republican and Democrat, between 2002 and 2020. And due to the recently announced illness of Justice Wilson, who's second from the right on top with the pearls, we're going to have a new justice to the Supreme Court appointed sometime in June or July of this year. Regardless of the fact that we have a referendum, we still have our current system in place, and so there will be at least Justice Wilson's replacement, if not another, before August of 2026, that's gonna follow that merit-based appointment system. And I mention that because I invite all of you to kind of pay attention to the process. It's your chance to see how the current process works in action. You can watch the interviews. You can look through the list of appointees or potential appointees and Google them and vet them yourself, see what public materials are published, but it's a chance for you to really engage in this part of the process, in which I know that other than attorneys and some other folks that just can't get enough of the courts, that, you know, that most people aren't paying attention, and I recognize that. But it's always been a public, transparent process that's available for you to look into and to have a lot of knowledge about. And I think this merit-based system has served Kansans well. It's prevented scandals. We don't have partisan politics controlling the system. We don't know what the outcome's gonna be before the decision comes down. And our justices should not be running statewide campaigns while trying to hear cases and render decisions that could impact some of the very people donating to those campaigns. Instead, myself and KWAFF, we believe it's important that our clients, to the bar, to the integrity of our court system, that our justices should be focused on the facts and the law before them and not on the opinions of political contributors. The merit-based system ensures that the judges to the highest courts in our state have the experience and skills necessary to interpret the law. That's their job. That's what's gonna serve the best interest of all Kansans. Again, the Supreme Court Nominating Commission transparently and publicly conducts interviews with candidates. They follow a process, the same process every time, designed to select the most qualified candidates to submit to the governor. And then the governor also takes the time to vet and consider all 3 of the finalists and ensure that the ultimate selection for our highest court is one that will be fair and impartial for all Kansans. So in closing with my comments, I think the best way to protect the independence of the judiciary and ensure that the Kansas Supreme Court remains free from political influence is to, of course, reject the constitutional amendment and vote no on the August 2026 primary ballot so that we can retain our merit selection process and keep our courts free from partisan influence, and continue the good work that our courts do. So I would love to take questions and discussion now.
Okay, thank you, Nicole. That was really clarifying to me. How many people feel like they have a good understanding now? Okay, and again, this is being recorded and be on our YouTube channel on Women for Kansas, womenforkansas.org. So if you talk to friends or family about this program and they say, oh, I wish I could have heard, oh, you can hear it. Go to the womenforkansas.org side, the YouTube channel. So for now, anyone having a question for Nicole on the topic of this issue, just raise your hand, I'll come around to you, state your name and your question. Yes.
March Mayor, it's just a real technical question. So what is the role of the Chief Justice and how is that person selected among the Supreme Court?
That's a great question. The Chief Justice is usually selected by the other members of the court. It's often the person with the most seniority, to be honest. That's not always the case with the Court of Appeals, again, because of the administrative lift of that job. There's so many cases. But for the Supreme Court, they typically do hear all of their decisions together as a unit of 7. So the Chief Justice is typically the person with the most seniority. And what that really means is they have a lot of extra work to do. They don't have an extra way to vote or anything like that, but they are in charge of the greater organization of the courts, some of the personnel matters, and some of the administrative matters. That's a great question.
Okay, anyone else with a question?
You're much better. My girlfriend has a question. But you go first, please.
Well, thank you for being here and for your presentation. Is there a limit to how many members the Supreme Court can have? And has it been raised?
Yes, that's a great question. We started, when we became a state, 1861, we started with 3 justices. I think that was more than adequate for the population size that we had. In 1900, there was a new amendment that expanded it to 7 justices, and we are still at 7. Now, just like the United States Supreme Court, the Kansas Supreme Court can decide whether to take a case. They don't have to take every appeal that comes. And so I think that the 7, I've never heard that the 7 justices wasn't a good number or that we needed more, because they are in control of which cases they take and issue written opinions on. And also with the advent of technology, like thank goodness, we can access every single opinion that any of these courts write. And that really wasn't the case even 15 years ago. We had like a distinction between a published and an unpublished decision. Decisions that were published actually had significantly more weight and precedential value on the court. So if you want to point out, Judge, this case over here was published and it was decided and this is what they said, so we should follow that same suit, or we shouldn't, but you would be able to talk about that opinion. Things that weren't published, it seemed like it was a lot harder to even, one, get your hands on to see how something was decided, but then also, does it really carry any weight if it's a matter of whether you found the opinion versus whether everyone's aware of the opinion? And so now, because of all of the automatic publishing of even district court decisions, I think it's really expanded our ability as practitioners to say, here is how the law is situated, here is how similar courts are finding, and here's how our own courts are turning out opinions on this issue. And so I don't think they feel as much pressure to take more and more and more cases. They're very selective, and I think they've done a good job selecting things that they feel that either the citizens are crying for an answer for, or that practitioners are really asking for there to be a resolution between, conflicting viewpoints perhaps at the lower courts. That's a great question.
There's another question.
Oh, wait.
My name is Shelley Scott. I seem to recall that during Brownback's term, there was an effort on his part to change the way the nominating commission worked. And I can't quite recall the details of that, but I was wondering if you could relate that.
Yeah, he did. This is not a new endeavor to change what's going on in the courts. There's been different attempts through different processes. The Kansas Court of Appeals, for example, was created by statute, as opposed to being created by our foundational constitution document. And because of that, we can actually, the legislature can manipulate and change what happens to the Court of Appeals, how many judges, how the nomination process works. I know Senator Francisco has been involved in some of those votes. But I believe that's how we got to Senate confirmation in the first place. The whole reason that the Court of Appeals has this extra step of Senate confirmation is because the Kansas legislature decided that they wanted to have a say. And frankly, they have had significant influence on who is put, or I guess selected for appointment pending that confirmation. They have famously rejected twice Carl Folsom, who's now a district court judge here in Douglas County, because he was a public defender. That's it. There's nothing wrong with the character of the man. He's an excellent jurist and legal scholar, but our state legislature doesn't like the fact that he was in public defense of people accused of crimes. And so the fact that they do have some control, they've been trying to wield that in many different ways, sometimes successful, sometimes not. And Senator Francisco, if you'd like to weigh in, I mean, you participated in these votes, so I'd be interested to hear your take if you want to speak to it.
Marcy Francisco. I would just say it has been an ongoing process, and probably the decisions that you highlighted added to the interest in changing how we get our Supreme Court justices, if that would be a way to change the Supreme Court. However, they've always looked at that. I think the real change was redistricting and having very strong supermajorities in both the House and Senate. So even though some individual legislators have some qualms, they went ahead and had the votes this year.
Karen Barrett. I have another question about the nominating committee. You said that the 4 non-lawyers are appointed by the governor. How does the governor go about that? How does that work?
Yeah, that's a good question too. I don't know precisely how you would submit your name for it, but the governor appoints a variety of positions. There's different state review boards that have citizens, non-lawyers or non-professionals still sit on those boards, and so this is one of many appointments that are made by the governor. I hate to say, I am sure it's somewhere on the website, because anything where you have an opportunity to apply for or participate in that appointment should be there, the process for which they select. And I'd be happy to get that information more specifically to Kelly and to you, and I know Ron, so we can exchange that. So that's a great question. I don't actually know, other than the fact that the governor selects them, what process people can do to apply. That's a great question, and that's a great way for our citizens to get involved. I mean, a lot of people would be well suited to sit on these commissions, and it is a matter, instead of just knowing the right person or who to ask, to be able to kind of keep an eye on it from a public perspective, so that you know what's coming and can have an appropriate person, put in for that position. So I will definitely follow up with you, Karen. Thank you.
Okay, Brizzy Golf. Supreme Court justices are from all over the state of Kansas. Do they have a district? And what would happen with this amendment? Would we then have areas like Wichita area, Sedgwick County, and Johnson County, then probably having the most judges from their areas, and our rural cities would be left out? Is that a valid thing to say?
Yeah, I think that's, it's a valid point. Right now, there is no districts. I mean, they do have a position number, kind of like the amendment spoke to, but it's not divided by geographical area. I will say, because I take a very keen interest in who's going on the courts and where, even if it's not in my jurisdiction where I practice or live, because honestly, a lot of these folks are my colleagues. I mean, it's very exciting to watch people grow into a spot where they're ready to seek appointment or put their name in, and so it's something I follow. What I've noticed is the Supreme Court Nominating Commission, we really can't predict who the 3 finalists are gonna be. And I think that's great, first of all, that there's not always of course those 3 are going up to finalists. I mean, they really do pay attention to the geographic balance of the state. And that speaks to the commissioners being from the 4 districts as well. So you have 2 people from each congressional district on this committee, and so they're going to always be thinking about that. One of Governor Kelly's latest appointments, was from someone from Pittsburgh, right? Which wouldn't necessarily politically help anyone, but it's not the point. I mean, just who is well suited, who has the merit, and then making sure we have a well-balanced, court. So I think there's two ways to answer your second question. One, right now, there is no mechanism whatsoever that says, within this amendment framework, that the justices will be selected from districts. It would most likely just be like Secretary of State, Attorney General. It's a statewide election. And yes, the reality is most likely to come from Johnson County, from Wichita, maybe Kansas City, Topeka, Lawrence pocket, right? But for a statewide race, that's what we could expect, because that's the success that we see. What I've heard is that there's a lot of legislators trying to assuage concerns, like, oh, we'll make districts, we'll make sure that your rural district out in Garden City is covered, and honestly, they're empty words to me, because there's nothing in writing saying they're gonna do that. And I just can't imagine leadership all of a sudden deciding that they'd like to make sure that Western Kansas or Southwest Kansas has representation on the board. So I know that's something that was tossed out during all the deliberations on trying to whip votes for the concurrent resolution, but it is not in writing, and there's been no bill introduced that would do that. And frankly, I don't know if we'd have to go back to another constitutional amendment to manipulate that, you know, and I think that's, so what I would tell people as you're explaining it, like to get out of the weeds here, is that this is a statewide race. We're most likely gonna just see big boys running for these offices from big cities. I think it really would eliminate the parity that we have with people from all swaths of the state. So that's another great point, another reason why I don't think will be a good system, is because we'll lose that. We'll lose that value, that historical knowledge, all of their perspectives, which are very valuable, especially when we're looking at appeals processes and, you know, what's best for the state, what's best for these litigants, what's happening. You can't just have big city folks on board. So, yeah, that's a great question.
Other questions?
Here. She could ask me later, but she warned me she might do this.
Go ahead.
Can you hear me?
Yes.
Okay, what do you say, what's your response to the criticism that the less political and more democratic approach is to grant the ability to elect justices to the people? Like, I understand the outside influence argument, but why isn't the best approach to give the people the opportunity to sift through their options and elect the justices at the end of the day?
Okay, so why isn't it more democratic to have the election
Yeah.
of justices?
She's tough. So, you know, I will emphasize that one, the outside influence is scary. You know, that's not our state, that's not our people. I think Kansas has always pushed back against those type of measures. And so it does concern me with just the sheer amount, the overload of influence. And maybe if we didn't have Citizens United, you know, which again is a decision that says that, like, it's a free-for-all now, how much money can go into these races and different referendums. If we didn't have that and we had restrictions, I think it would be a lot closer call, frankly, I do. But with that, with it just being unfettered amount of money coming in from anyone in the world, in the country who wants to donate, I think that's a serious concern. The other thing I speak to that we haven't talked about yet is being on the court, being an attorney and judge, it's not just a profession. I mean, it's a practice. The way that physicians talk about the practice of medicine and the lifelong learning process that goes into becoming and remaining the best doctor they possibly can be. You know, the law is like the Constitution, like this ever-breathing, changing document, and the interpretation of these laws has to change constantly with the way that our state grows, with the different things that happen with our people, with different technologies advancing. And so to say that any Joe Schmo who has a great smile and a good suit can be on the court is just missing the point. We need our best and brightest scholars on the court. Most people don't apply until they have had 25, 35 years of experience. Because it's something that you come to with wisdom, with practice, with seeing academically, all the ways that the laws have changed and grown over time. The analogy that we make a lot is if you had a group of doctors and they, or a group of people who wanted to decide who's gonna be the surgeon, who's gonna do the heart transplant. Do you want the best surgeons in the hospital in a room deciding who the surgeon for the heart transplant is, or do you wanna take a soft poll outside in the city? Right? I mean, it's the same thing. This is not something that you could just run for election at, read a couple books, get up to speed, and start making decisions. What concerns me, and I think what would happen, is if you're gonna have practitioners who aren't scholars of the law, who are just lawyers, JD trained, eligible, but otherwise are coming from who knows what sector to come in and run for a seat on the court. And once they get on the court, we have to ask, are their opinions coming from their astutely study of the law? Or is it coming from what they think the better political outcome is? I just think that what I would tell people is that you would never want a group of folks deciding who your surgeon should be. You want the surgeons deciding who the surgeon should be when it comes to doing the most important surgery of your life. And the people before this court are having the most major decisions of their whole life litigated in front of them. So we want our best and brightest. And also I would say that the public does get to participate. It is a beautifully balanced system. You get to vote on whether to retain a justice. And even though all of our justices have been retained, and I will tell you, lawyers have different takes, but I vote to retain every single time, all of them. Even a few I don't care for. And that's because I respect their position on the court. I respect that they have a different opinion than mine. I respect their ability to interpret the law in a perspective that I haven't gained. And sometimes I feel more comfortable with the prevailing side, and sometimes I feel more comfortable with the dissent. But I support wholeheartedly their right to be sitting on the court. They went through the process. They're more than qualified to sit, and they should remain so. And so yes, that has been the case for all of our Supreme Court justices, but there have been a few judges in Sedgwick County who they do go through retention, and some of them had upset the public so much that they were not retained. I mean, so the public is capable of choosing not to retain. It's not just become this automatic vote where we just know, oh, well, the public will always retain. I mean, we have seen the public say, no, I'm really unhappy with the behavior of this particular judge, regardless of the opinions, and so he's out. So we're smart. We're smarter, than we give ourselves credit for when it comes to voting on these things, so.
I have kind of a follow-up question on that, assuming that we would end up with the election process versus merit-based. Besides retention, is there any other kind of clause, an impeachment clause, if there were a justice that were elected, but then the public felt, or the state felt that this person was not qualified, is there a way to remove them from the?
Yes, so all attorneys have a code of conduct that we have to follow that is outside just even the regular criminal and civil statutes, right? It's called the Kansas Rules of Professional Ethics, I believe. And within that framework, there are several things, including stealing clients' money, breaking confidentiality. There's a lot of things that would apply to judges. The judges also have their code of conduct, and if they violate that severely enough, yes, they are in front of a disciplinary board, and there are procedures in which they can be suspended or removed, even from their seat. So, we haven't thankfully had a scandal of that magnitude, but there is a mechanism. Now, how that would work with the partisan elections and all that, because that's not created under the Constitution. Us having our ethics code, the judicial ethics code, is not part of the Kansas Constitution. So how those two things will continue to work together is an unanswered question. I don't know, but there are mechanisms right now in place that if something bad enough happens, you don't have to wait the 6 years on a retention vote to decide. There is an internal and partially public process that says this person's being subject to disciplinary proceedings, and some of that information is made available. I know some of it is like protecting the due process rights of the attorney or judge, so we can't just say, Nicole got a DUI, and now she's in the disciplinary process, like, that, you know, I would have some rights not to have that public, you know, made public. But eventually, if there's some sort of consequence to my license, to my ability to practice, same for a judge, those rulings, those decisions are published and word gets out, it's not kept under wraps. So that would be interesting. And frankly, if we did move to elections, it might come into play a lot more, you know? But it does exist. We have an entire disciplinary review panel, and there are grounds for suspension and removal, because if you no longer have your license, then you can't sit on the court. Just like I couldn't practice law in my office. So that's a great question, Kelly.
Is there another question? Anybody? Karen?
Well, I was really kind of thinking of two things. The one thing I was thinking of is that I feel that the election process might make people not apply who would be a good candidate just because they don't have the money to run for office, because they don't want to run for office. They would fill out the lengthy application you talked about and go through all that, but not run for office. And the other way I was looking at it is like, will there be any sort of baseline? Could I run for the Supreme Court just because it's an elected position? This was something that always puzzled me where we lived in Alabama, where the coroner was elected, and I was like, well, I'm sure, hope that they have at least some sort of medical background.
Yes, I think, and I remember on the drive over here that I didn't look up the specific rules, but we do have, kind of like being president, you know, you have to be this many years old, and, you know, there are some basic requirements to become a justice. I would think those remain the same, because again, they're not eliminated through the amendment. So you have to be a licensed attorney with a Kansas license. I also believe you have to have a certain, you know, it's not about being a certain age. I believe it's a certain number of years as a licensed attorney in the state. But I can tell you that that is already happening, what you fear. What are best and brightest for people who otherwise would have certainly put in for the court, who have worked their whole career for just the opportunity, which is, you know, a combination of right time, right circumstances, right place in that person's life to put themselves in front of that appointment. And there's already been folks who are either hesitant or not willing to put in for Justice Wilson's position or any other position that opens up before the ballot, because they're thinking, I'm not running an election. I'm not gonna do that. Or I couldn't do that. You know, if you've never been a part of the political process, which our judges are trained not to be. I mean, you have to remember, they spend their whole careers staying away from politics. And especially when they become a judge, they shed that. They don't give money, they don't go to events, they don't take a position, they don't talk, they don't put it on social media. They really insulate their lives to dedicate themselves to being unbiased. And so then you're asking, open up the lid and come on out and tell everyone what you think about everything. I mean, it is the opposite of what they're used to, of what they feel ethically is appropriate. Yeah, there's plenty of folks who are already, that would be excellent on the court, who are just pumping the brakes, I'd say. I mean, we don't know the list of people who put in for this seat yet, but I do know that it's been influenced already, and I think it would continue to be so. Because now you need to find, well, who's gonna run my campaign? And if you're a sitting justice, it's, well, I have to do my job. How do I do my job and get to Garden City? How do I do my job and go to Hayes? How do, you know, it would become a bit of a circus. We're a vast state, as we know. So travel is not so simple to cover, you know, campaigning, like literally. It would be quite a lift, mentally and emotionally on top of, and politically, you know, as ugly as it gets. So I think that for a lot of our potential candidates, I mean, that's a huge factor in whether they're going to put in. And I think until we resolve this ballot issue, it's gonna have a chilling effect on a way. I don't think this is gonna be the same group of candidates we would have had if this amendment wasn't coming forward. Doesn't mean I don't think we're not gonna have great justice and great people to select from. We just know it's maybe a different group than we might have otherwise gotten to consider.
A couple comments here.
I just had a couple quick ones. I had never heard that the nominating, the interviews were public, and how would you find out how to?
They're on YouTube. Yeah, they're gonna be on YouTube. I think they always are, and my understanding it's gonna be the first or second week of June, somewhere around like the June 9-10 framework. Like, don't quote me on it, but I think that's the slated timeframe. The courts, I believe, so the court has a website. The Kansas Supreme Court has a, thorough website that talks about a lot of what I talked about here today. The courts, the makeup of the courts, the nominating commission, and I think when there's a vacancy open, they will actually publish the schedule of when that's available. But it's live on YouTube, and it's coming up in June. But the slate of nominees should come out, frankly, this week. Find out all the names of the people who put in.
Okay, and then, this amendment is coming to a vote in which election?
The primary,
In
course,
August?
the primary of August 2026.
Real quick, I think your question would be, what do you type in when you go to YouTube? What do you type in? What's your search?
I would do Kansas Supreme Court nominating commission.
I had a political question, and that would be, it's 2025, we've got another year plus, 5 months or whatever. The public attitudes toward the US Supreme Court and the perceived lack of neutrality in the court, how would that affect, do you think, this election?
I think what I'm excited about, I'll tell you what I'm excited about. When we had our 2022 vote, let's make no mistake, we need the same soldiers, right? When we had our 2022 vote, we knew about it for a while, but we really hadn't organized. We really didn't have a momentous opposition, and I frankly thought, oh, this is a done deal. They had a great campaign and a slogan and the whole thing. And it was the Dobbs decision that ignited a fire in all of us to just rapid response, get together and get organized. So what excites me is that those folks who organized in new organizations or joined existing organizations, they're still here and they're still organized. And that's an advantage we didn't have in 2022. What it's gonna take is a huge education campaign. It is. I mean, you have to be able to tell them, this is how the courts work. This is why we don't want elections. This is what the nominating commission does. This is why lawyers aren't scary, no matter what the explanatory statement says. I mean, they love to just say, the lawyers choose. As if that's a bad thing, frankly, because really it's us figuring out which of our colleagues are the most qualified to be sitting on our court and rendering decisions that could affect us every day is the ultimate symbol of respect. So I would reframe that, those attacks on the attorneys being part of the process. But what I think is we have a year and a half to teach everyone what this is about and why. And the why is what motivates people to vote. The why is they want to get rid of abortion. The why is that they want to get rid of school finance stuff and go to vouchers and let our public funds be used for private schools and religious schools. The why is what is going to get them out to vote. So remind them, yes, I can teach you all about this process, but you know why they're doing this? Because they can't stand that we have a constitutional right to abortion. They want to flip that court so bad they are willing to put an amendment up to force it to go to elections so that all their friends can donate millions and millions of dollars so they can buy the court because they're tired of being told that they pass unconstitutional bills. I mean, that's the why. That's why we get them.
So Marcy Francisco, I have a question that I know the answer to. Who writes the explanatory statements that appear on your ballot?
Someone in your wheelhouse. I actually don't know who writes the actual explanatory statement. Who is it?
The legislators who introduce the amendment.
Yeah.
So,
Yeah.
almost every time that we've considered a constitutional amendment in the Senate, I have offered an amendment to change the language. Because although this language is true, it's misleading. So instead of saying you have 4 attorneys, might be a better word than lawyers to use, then it says a majority who will be lawyers. So I think I had 6 or 7 more questions, and they thought it would make the ballot question too long.
No, I was watching you do that, and I appreciate you trying to put in that amendment. You know, there will be a campaign saying, you can't let these sleazy lawyers pick the court. I mean, I'm sure, but all right. Just remind them of what this is really about. Yes, true, technically, 5-4, majority of lawyers, but I mean, I guess that's another thing that they're gonna say that is just completely untrue, that somehow the 5 lawyers vote in a block, and then they always get the people they want, and the non-lawyers are just sitting there, those cute faces, not participating, and like, that's not true at all. I mean, it is really a comprehensive process. Everyone's vote is weighed equally. The lawyers don't have a vendetta. We weren't really smart people up there. We have to live with what they decide, and we have to be able to understand what the heck they're saying, which isn't always the case. I mean, so we have to read their opinion and then say, okay, what do they mean by that? And just hope that they were articulate. And plenty of times they aren't, you know, or they kind of got there, but we have all these other questions, and they don't take questions after they make their opinion. They just go back into change. So we want our smartest people there. I would just make the surgery analogy again, but yeah, it is not a process that's wholly taken over by lawyers or with some scheming agenda used by lawyers. Like, yes, our agenda is we want our best people on board. Hands down.
Okay. This is really just a follow-up to the question that was asked earlier. And it's not because I want to apply it really better, but what kind of people are the other people besides the attorneys? I mean, like, are they just random professional? I mean, what kind of people are the other people?
Yeah, I think it's really well-respected, well-rounded people of different professions. I mean, very intentionally. I know in Shawnee County, we have a teacher on our Shawnee County District Court Nominating Commission. So yeah, I think you'd want to have folks that have their own well-balanced perspectives, whatever they're bringing to the table. So I don't know that we just go off and grab a citizen off the street, you know. But essentially, anyone could be on these commissions. Like, I've never seen there be a standard to which it's always, you have these big boardrooms and it's like the CEO of the banks. That's not, I don't interpret that to be how our nominating commissions are. I think it's a really nice broad swath, and especially with having Governor Kelly, she's been very intentional about getting more women, more people of color, more well-rounded professionals. Like, she's not going straight to corporations to figure out who to put on her boards and commissions. So it's another way the governor has a lot of influence on these processes.
And that's a good selling point. If you can say citizens, just regular citizens that have credibility are on there, that's a good selling point to keep it the way it is.
I have one final question, comment. I know this is gonna be a big issue for Women for Kansas, just like the Vote No campaign was, the ACLU. Groups are looking at forming, coalitions to work on this together, and my understanding is, maybe Marcy can help us out with this, Senator Francisco can help us with this, or if you know, that the legislature passed a bill regulating the way people can raise and spend money in regards to constitutional amendments. Are you aware of that at all? Is that not true? Okay.
There was a bill that changed the amount of contributions, but I don't believe that that affected a constitutional amendment. And because it's nonpartisan, it's much more open in terms of contributions.
Any other questions?
Kelly, I would tell you, there are some issues with that bill, and it does kind of impact the way that organizations have to disclose certain amounts. Not with the amendment necessarily per se, just in general, that it would kind of change the nature of, well, this organization is supposed to just be able to collect funds and not necessarily disclose all these different things, and that, but it has to do with the ties to foreign nationals, which is a very tenuous thing. So you're not wrong to be thinking that that could have some sort of impact, whether it directly impacts this, I don't think we know yet, but it's just the fact that it's out there, scares people into worrying about, how do I comply with this? Are we compliant with this? Can we collect money? Should we stop? It's kind of like League of Women Voters had to stop registering voters when they could be convicted of a felony for looking like an election official. So it has a chilling effect, and that's important. So that's something to keep an eye on as we go forward.
There was a decision coming by July 1st that we're gonna be waiting on, so I don't know.
Got it.
Okay, well, this has been enlightening. Help me thank Nicole.